We now turn to the fourth case on this morning's docket. Case number 115352, Kelly Casper v. Kansas Department of Revenue.
May it please the court, Jonathan McConnell on behalf of the petitioner Kelly Casper. And Your Honor, if I may reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. Brief history of the case. Factually, this was a DUI arrest. On the criminal side, ultimately the case was tried. My client was found not guilty. On the civil side, we had the administrative hearing. We lost. We appealed that to the district court, where the district court ruled in our favor. Ultimately, the Kansas Department of Revenue appealed that decision. The Court of Appeals reversed the district court, and so we filed our petition before this court. There's several issues today. The main one that I want to focus on, is I believe the Court of Appeals applied the incorrect standard in this case. I believe that the court ultimately should have determined whether or not substantial competent evidence was there for the court's decision. I think the court redetermined and reweighed the factual findings of the district court, and we believe that that would be inappropriate.
Well, apply the standard. What standard of review should we apply in this case when we're looking at whether reasonable grounds exist?
In looking at reasonable grounds, whether or not they exist, I think that ultimately you have to give deference to the district court of their fact finding. And then ultimately,
so we would look as to whether substantial competent evidence supports the district court's factual findings.
Correct.
And then what would we do with our legal determination? That's a de novo review, correct?
That's correct.
Okay, and then how would we apply that to the facts of this case?
I think ultimately you have to give weight to the findings of the district court. And ultimately the district court was in the best position to listen to all the evidence, to hear the live testimony of my client, of the arresting officer, to view the video, and then make a determination of the credibility. I give the court an example. I think what you're alluding to is the officer indicated that my client failed field sobriety tests. So if you look at the DC-27 and you see the boxes checked, if you take that as gospel, then perhaps that's correct. But if you watch the video and listen to the cross-examination of the officer, there was questions of whether or not the officer even gave correct instructions and administered the test correctly. So I think ultimately the court, in viewing that, was saying the court believed that while technically she could have failed field sobriety test, that may not be accurate, may not be an accurate indication of impairment.
How do we view, I asked this in the prior case too, how do we, as the appellate court, view the video evidence in this case? Let's say there's a observation and the testifying officer says that Ms. Casper used her hands to balance, and we watch the video and it doesn't appear that there's any use of her hands to kind of regain balance. What does that mean? If that's an observation that do we give deference to the officer who's trained in doing this and say there's different ways you may use your hands? I was having trouble determining several different aspects of what the testimony was. It didn't seem consistent with what was on the video.
Yes, I think ultimately, do you give deference to what the officer believed? No. I think you use your own judgment as to was that an accurate indicator of impairment. So I think what happened in this case is the court the court believed that the officer believed that these were indicators, but I don't think the court believed that those were accurate indicators based upon the testimony of the officer, based upon the testimony of my client, and based upon what the video showed.
If we do what you're suggesting, counsel,
Yeah.
just look at the video and make our own judgment, then why are we
Right.
not engaging in exactly what you accuse the Court of Appeals panel of engaging in?
I would say that ultimately the Court of Appeals did do that, of what I'm
And you're
accusing of
telling us
engaging
not
in.
to, aren't you? I mean, your position is it's inappropriate for appellate court to do that, right?
Correct.
So if we just look at the video and we go, I don't know, she's using her hands, she's not using it, we make our own call on what we see, then why are we not just being fact finders?
Perhaps I misspoke.
Okay.
To clarify,
Counselor,
yes.
maybe we could not talk past each other. The district court bought into the driver's argument and said she met her burden of showing there was not reasonable grounds, correct?
Correct.
So the factual findings have been made by the district court already,
Correct.
okay? And so you're asking us to accept those as being supported by substantial competent evidence.
Correct.
And so then I guess the question is, how do we decide if it's substantial competent? Do we look at it and make our own determination, or is that fact finding?
I mean, the court, of course, the court could. I don't think that would be appropriate. I think the court needs to defer to the fact finding that was made by the district court judge. And to clarify, just to be clear, I think I'm trying to explain how I believe the district court judge came to that decision, and I believe that the Court of Appeals obviously didn't like that decision and attempted to reweigh the credibility of the witnesses in the testimony, which I believe was inappropriate.
Is there any way that in your mind, without reweighing, is there any, if we defer to and find substantial competent evidence at the district court level, is there any way that the Kansas Department of Revenue can prevail on appeal?
No.
There's just no way. It's not.
In our position, it would be no. It would be impossible.
I understood you to say that the legal conclusion as to whether there were reasonable grounds was a de novo review, and we could make our own conclusion based upon findings from the district court that are supported by substantial competent evidence. So is what you just said inconsistent with what you said earlier?
This court can review the ultimate legal conclusion, yes, but I believe it has to give deference to the fact finding of the district court. And I believe
The degree of deference is just substantial competent evidence, though. I mean, that defers, but as long as there's evidence to support, substantial competent evidence to support, then we defer, right? That's still a precursor.
correct.
On the,
So we're
on the,
using-
on the factual
on the
findings,
fact findings.
Correct.
but we do not defer on the ultimate legal conclusion of reasonable grounds.
Correct.
All right.
So are you suggesting that the Court of Appeals went one step too far, and instead of just saying there wasn't substantial competent evidence, they also said there wasn't substantial competent evidence and this is what the evidence is? Or are you saying they even skipped that step of saying whether there was or wasn't substantial competent evidence?
I believe that they skipped that step of whether there was or wasn't substantial competent evidence, and they took it upon themselves to then reweigh those facts. I believe that's what occurred in this case. I believe that's inappropriate for them to do. That they needed the factual issues. We needed to give deference to the district court.
What's the difference between reweighing and simply determining that as a matter of law, these found facts establish probable cause? Because I guess that's where I'm getting hung up. It seems to me one way to read what the Court of Appeals did is very simple, to say the Court of Appeals said, here's some facts that were found below, certain number of markers on sobriety field tests. Mm-hmm. She admitted she had drunk something. There was a traffic infraction. Therefore, as a matter of law, these found facts are sufficient to establish probable cause. Isn't that a legal determination?
I feel like the Court of Appeals went a step too far and wanted to give a blanket statement as far as the court couldn't find substantial competent evidence because there was a quote-unquote fail on field sobriety test. But if you gave deference to the district court and their facts as they saw it, the court didn't believe that. So the district court believed that yes, there perhaps was a technical fail in the field sobriety test, but that wasn't perhaps credible. That wasn't a good understanding or indicator of impairment.
Well, that's not what the district court said, though, right? I mean, you're not contesting the finding of fact that the Court of Appeals recited as to the outcome of the field sobriety tests.
No.
And so if the Court of Appeals, the Court of Appeals decision is not this clear, but let's say it had simply said, as a matter of law, when there's these number of markers on a field sobriety test, that equals probable cause. Wouldn't we then be talking about a question of law, really?
Hypothetically, we could, yes.
But the substantial competent evidence of a failure of an FST is the evidence is typically, one, the officer's testimony and description, and sometimes a video of what transpired. And the district court is capable of viewing that evidence and determining whether that's substantial competent evidence, part of which is the credibility assessment of the officer who subjectively says the hands were 8 inches away instead of my described 6 inches. So that would impact the factual side of it, wouldn't it? If the district judge looked at it and says, no, the performance I see on the video didn't fail, even though the clues recited by the officer, like you say, the officer thinks it was these clues, but it's not corroborated by the video, then why isn't that a factual finding or a determination of the competency or substance of the facts?
I agree with that. I think that goes to the weight and credit that the district court gave to the evidence that was presented before it.
And then the next question is, if that is in fact what happened, the trier of fact looked at it and said, no, that doesn't support what your conclusion is, which is a failure, then what do the appellate courts do with that video? And I think that's the question is, can we make an independent determination of no, the district court didn't view that video correctly? I think that's the whole issue is can the Court of Appeals look at that video and come to a different conclusion than the district court?
I don't believe so. I think they need to defer to the factual determinations that were made by the district court.
But they have to have some facts, some evidence in the record to see that they support the finding of the district court, correct?
Correct. And
Otherwise, it's not supported by substantial competent evidence.
Correct.
And then ultimately, once they've made these findings, it may be that the district court said, I don't think that this person failed any of these field sobriety tests. And we look at it and the person performed like Superman. And we say, yeah, you're right. That is substantial competent evidence to support the finding. And without that evidence, you don't have reasonable grounds.
Correct.
Correct?
That's correct.
Okay.
And I believe, if my memory serves correct, in this case, I believe the judge gave a very detailed record and found at least 16 reasons as to why he didn't believe that it was a lawful arrest of my client based upon field sobriety test, amongst other things.
Justice Stiegel, you still have a question?
I guess it's just a follow-up on your question, Chief, but very specifically, in those findings of the district court, did the district court make any fact findings as to the failure or non-failure of the field sobriety tests?
I believe what the court went through is, it went through in detail, to give you an example of, if I can, one moment find it here. I think the district court reviewed the video of the field sobriety test and tried to do an objective analysis and gave examples of how the officer gave instructions very quickly and in fact messed up on the instructions. An example would be the officer, I believe, informed my client she needed to take 3 steps instead of 9, and then she looks at the officer and clarifies, is it 3 steps or is it 9 steps? So I think the district court was questioning the credibility in its mind of the outcome of the field sobriety test.
And that just goes to the Court of Appeals statement, which I presume you find problematic, that rather than relying on subjective observations of Casper's behavior, the district court should have relied on objective results of field sobriety tests.
Correct.
That's where I'm trying to figure out if that's really can you fairly divide subjective observation from these alleged objective results of field sobriety tests?
Well, I think it could be argued that the field sobriety tests itself are supposed to be objective, but the interpretation is clearly
This case puts that premise to the test, doesn't it?
It could be perceived that way, yes.
Just real quick before you sit down, do you see a difference between how we would, between probable cause and reasonable grounds? They're used interchangeably in our cases and also even in the district court's findings. Do you see a distinction?
I do. I think that what the court found in this case, that there was probably enough reasonable suspicion.
No, not reasonable grounds. Yes, probably reasonable suspicion, but the distinction between reasonable grounds, which is what the statute talks about, and probable cause to arrest.
I think that it is a different standard. I realize and recognize the court at times finds it analogous. The issue in this case being, though, that not only did the officer have to have reasonable grounds to offer the test, but it had to be a valid arrest. And a valid arrest would require probable cause. And the district court in this case did not believe there was enough probable cause to arrest her, so it wasn't a valid arrest.
Right, which would infer there wasn't reasonable grounds also.
Correct.
Okay, thank you.
Any further questions? Any further presentation? Do you need about 30 seconds to wrap up? I think you've made your points.
No, Your Honor. I'll come back and rebuttal. Thank you.
Okay, thank you.
May it please the court, Adam King appears for the Kansas Department of Revenue. May I proceed, Your Honor?
You may.
I believe it's important to start out by saying this case is fundamentally one about reasonable grounds. And to get to the question that was just asked, reasonable grounds and probable cause have been decided on the same legal standard. Where they differ is timing. Reasonable grounds is calculated at the time of the request for the evidentiary test. Probable cause is calculated at the time of the arrest. In cases like this, where the arrest is for a DUI and we're not talking about indicia of impairment after the arrest, the standard that the court will use to decide the question of whether it's reasonable grounds or probable cause will ultimately be the same. And for that reason, the Court of Appeals was correct in saying, in this case, it ultimately makes no difference because we're looking at the same factual scenario. When it comes to applying the standard of review on these questions, I believe the court is correct at this point that the appropriate standard of review to use in a reasonable grounds case is a bifurcated standard. The factual issues we examine to see whether the district court's factual findings were supported by substantial competent evidence. And then with the factual basis, appellate courts apply a de novo standard of review to the ultimate legal question of whether there were reasonable grounds. When we come to the facts of this case, really there aren't as many factual issues in dispute as Casper would have the court believe. The Court of Appeals was correct that when the Department of Revenue appealed this case from the district court to the Court of Appeals, the factual contention that the department was arguing was whether there was substantial competent evidence for how strong the odor was of alcohol that Casper exhibited. Was it strong? Was it not strong? What is the meaning of the term reek? And that is a case in which the Court of Appeals looked at the district court's finding, saying there's no evidence that there was a strong odor of alcohol, and looked at that factual finding in light of the record as a whole, and concluded that that factual finding was not supported by substantial competent.
Why? Why is a statement? I mean, the reeking of alcohol was a kind of a comment that was made while field sobriety tests were ongoing, and there was no testimony at trial, at the de novo trial, about anything about his observations regarding that statement. Why is that even anything that should be considered?
The officer was asked at the trial if she exhibited the odor of alcohol, and did indicate that she did.
But why the Court of Appeals said this reeking of alcohol that was a part of the video was evidence? And why is that considered anything other than just an observation that's hearsay at that point, without any testimony about it? Is it evidence that there was lots of statements made by both parties in the video that we wouldn't say are facts?
The district court appeared to credit that as a fact in its determination by finding, in fact, that the officer said that she did reek. And as the district court made a determination about that reeking, appears to credit that in his weighing of the totality of the circumstances. Whether or not Casper exhibited a reeking of alcohol as a factual finding, in fact, was not something that Casper cross-appealed when this matter was on appeal before the Court of Appeals.
There really isn't a factual finding. I mean, we're guessing a lot about what the district court might have thought. And I'm reading probably the same recitation from the transcript as counsel had. To me, that's one of the problems here. Is I can't tell what's a fact finding and what's the district court just saying, well, there was this evidence, and then there was that evidence, and then there was this other evidence. And that's how the reeking seems to fit to me. The court just says, well, the officer said that, but there's no fact finding, is there?
The reeking appears to factor in as inculpatory.
How do we know? I get that you say it appears. And there are some other pieces of evidence that your opposing counsel say, well, these appear to have influenced the district court's decision the other direction. But on review, it's really hard for an appellate court to get a handle on what the actual findings were when the court doesn't make findings.
I do understand that, Your Honor.
So what
I don't have the citation handy at the moment, but I believe the briefs do point to the citation in the transcript where that is referred to as inculpatory.
That's the problem. Just identifying an individual piece of evidence as inculpatory or exculpatory, which I think the judge does. He kind of recites, in fact, he interrupts the prosecutor, as I recall, and says, I think you're arguing with my ruling, and then he goes through each fact that and how he found it fell, inculpatory or exculpatory. But there's still ultimately not a decision where there's any conflict. is there? Is there any place you can point us to in the record where we can say, okay, that's a finding that we defer to, versus just inculpatory, exculpatory kind of?
I agree that the district court's use of language in making those factual findings was less than precise and clear.
Yeah.
But if the court is looking at how he's weighing the evidence that apparently is before him, that is the direction that the district court seems to be taking
Yeah.
those things that were brought out at trial and in the video. With reference to the facts that the court has upon which to make its de novo conclusion, legal conclusion about whether reasonable grounds existed, really a lot of those facts aren't in dispute. For example, it's factually not disputed that no preliminary breath test was given to Casper at the time. There's a lot of argument that's been made to the court that the Court of Appeals was reweighing evidence, so to speak, when it disagreed with the district court's conclusion of what that means to this case. Factually, however, the question is not in dispute. No preliminary breath test was given. And so the Court of Appeals isn't engaging in reweighing of evidence at the point where it disagrees with the district court. What the Court of Appeals is doing at this point is saying, we don't think that the significance of that fact, the significance of no preliminary breath test, means what the district court thought it means, should factor into its legal conclusion about whether reasonable grounds existed.
Well, in the district court, I mean, there's several references to it, but prior to making the initial conclusion that the department didn't meet its burden, was just saying it would have been helpful had it been there, but it wasn't there. That's really all that the district court concluded about the lack of a preliminary breath test, seems to me.
The district court seems to place significant weight on the absence of the preliminary breath test in its determination. I think, as the Court of Appeals rightly points out, though, the absence of a PBT isn't evidence of anything one way or the other. It may have been helpful, but we can't draw from that a conclusion about whether Casper would have passed or failed the preliminary breath test. It isn't part of the evidence that is to be weighed in this case. And I might just add, by way of an aside to that question, Your Honor, that in these cases, it's very helpful from the department's perspective to keep in mind that in these determinations, the burden is not on the Department of Revenue to prove that Casper was driving under the influence. That the burden resides with Casper to show there were no reasonable grounds in this case.
You were just saying how the Court of Appeals did not reweigh evidence, and you brought up the PBT. Do you think it's also true that the Court of Appeals was not reweighing evidence when the Court of Appeals stated that Casper scored 5 out of 8 clues on the walk and turn test and 2 out of 4 clues on the one-leg stand test?
No, I believe those were facts that were considered as inculpatory by the district court.
Was there, my reading of the district court record I can't find where the district court made that fact finding. I can find where there's evidence, there was testimony.
On page 49 of the transcript, lines 2 and 3, this is the transcript of the second day of the trial. The district court says, the evidence on the video, the failure of these tests is a factor that's considered, but it's also considered in light of all the other evidence and all of the exculpatory evidence. So It appears that the district court was crediting the fact that these tests were in fact failed.
That's where we look. There's nowhere. That's your best citation to the record.
There is another citation in the record which is referred to in the brief, in which the district court, in going through its inculpatory versus exculpatory findings, refers to the tests as inculpatory. mistakenly says that the walk and turn was exculpatory, immediately turns around and corrects himself and says inculpatory
Right.
as he proceeds along. I apologize, Justice.
No, thank
I don't
you.
have that citation here, but it is in the briefs.
Thank you.
Ultimately, what we come down to in this case is that the great majority of the facts, other than the reeking of alcohol, really aren't in dispute. And what we have is an extensive record of how the district court was weighing those facts in making its legal conclusion about whether reasonable grounds existed. The Court of Appeals ultimately disagrees with the analysis of what those facts show. The facts in this case that really are undisputed are we have a late night event. It's about 1 a.m. Casper makes a wide right turn in midst of consuming alcohol. As I argued earlier, the court credits the fact that she had an odor of alcohol, and I believe substantial competent evidence would show that the record would show that reeking characterizes the strength of it. Had bloodshot, watery eyes, exhibited 5 out of 8 clues on the walk and turn, 2 out of 4 on the one-leg stand that the district court itself characterized as failing the test.
Where are the 5 out of 8? Where does that come from? That comes from the Court of Appeals, doesn't it?
It comes from testimony at
Where the
trial.
Court of Appeals just read it and then count them up and say 5?
I believe those specific.
I don't think the district court was that specific in saying there's 5 out of 8.
That the clues on the walk and turn that are listed are discussed at some length in the transcript that the court can examine.
But it would require us to come up with the 5 or 8 or whatever, the number. The district court didn't specify the number, did it?
That I don't know off the top of my head, Your Honor, but I
didn't see
know
it anywhere in the findings.
I know that the briefs would point you to that specifically.
What do we do? You cited to page 49, but what do we do then with the court's long discussion beginning at page 52, where by the time you get to 54 and on, he's going through each of the field sobriety tests and saying the officer said this, but the video shows that she also, like for example, he said there might not be balance, but the video also shows that a lot of times she did have good balance. Doesn't that kind of erase, doesn't that later discussion after page 49 put us back to the point of saying that the district court may have given it some weight, but apparently not very much weight?
I think that it does show that, Your Honor.
And also shows that it's disputed, that there were failures on the field sobriety tests. I mean, that seems to me to be what he's doing, is questioning the officer's conclusions.
I would say that the district court finds that there's a failure of those tests factually. As he's discussing it and weighing that, he's explaining various reasons there could be for the failure of that test, how to characterize the failure of that test. And that isn't necessarily his factual finding per se. That's the officer or the judge in that case trying to evaluate what role he's going to give to those facts in his ultimate legal conclusion that there were no reasonable grounds. Something that the appellate court is in a position to be able to do from the factual basis as well.
The police officer isn't the fact finder, though.
Correct.
On what is successful performance, is it? Is the police officer?
No, Your Honor.
So it's the court.
The court, yes. If I misspoke, I apologize.
No, you didn't. I'm just trying to clarify here because what I think the district court did was take into account what the officer's testimony was, included his observations, and then made an assessment as to the credibility and made a determination on the field sobriety test.
Correct. I don't mean to interrupt you if you're...
No, that's fine.
In conclusion, I would just say that from the department's perspective, this case really comes down to the question of, here are a number of facts that were presented by the district court. The district court analyzed one way. The Court of Appeals analyzed a different way, but that analysis was not a reweighing of facts. It was drawing a different legal conclusion from facts that are ascertainable both in the record and the video itself. And we believe that the Court of Appeals' determination that those facts show legally that reasonable grounds existed is correct.
Do we have any further questions? Thank you, counsel.
And I really don't have, may it please the court, don't have that much in addition to offer. I'm happy to answer any follow-up questions the court may have in light of Kansas Department of Revenue's.
I have one.
Yes.
If we conclude that there are no findings of fact below, what should happen to this case?
Remand it to the district court to make those findings. I believe that would be appropriate. I think our position would be what the court was trying to do is it was making findings of fact, and it was attempting to clarify for the state why it was coming to that conclusion. So it walked everyone through the beginning to the end of the encounter and why the officer may have perceived it one way, but why it could have a completely innocent explanation on the other end. And I think ultimately, based upon the district court's determination, it believed the opposite of the officer. So it found the officer credible that he believed that, but I think questioned the credibility of that.
Counsel, I'm sorry, Justice Stegall, were you done with your question?
Yes, thank you.
In looking at the Court of Appeals decision, it says, among other things, in finding the officer lacked probable cause to arrest Casper, the record shows the district court considered the totality of the circumstances. It noted, among other things, Casper failed the field sobriety test.
I guess the answer to that would be that I think the court was stating that technically she had certain indicators of impairment, but the court didn't believe that those were actual indicators of impairment, that there were other explanations. As far as giving an example of she's credited with not following directions. Well, if you watch the video, what she's really doing is she's stopping the process and asking the officer, do I really need to take this test? So-and-so told me I shouldn't take this test. So it could have been a technical violation, but he didn't believe that it was an indicator of consumption of alcohol.
Well, that explanation, or one similar on that particular point, Casper failed the field sobriety test, does not appear in the Court of Appeals opinion. So did they misunderstand or misstate what the district court actually had found?
My recollection would be that, yes, they perhaps didn't understand what the district court stated.
Okay. They seem to be focusing, as was indicated early in the oral arguments, about ultimately the district court determined the officer lacked probable cause, namely because a preliminary breath test, PBT, was not performed.
And I don't believe that's an accurate characterization of what the court was doing. I believe...
Which court? The district court?
District court, yes. I don't believe the district court judge was saying they needed a PBT. I think he was trying to explain to the state that perhaps a PBT could have answered the question ultimately, but one wasn't offered. And I don't think the court found it credible that the officer didn't have the ability to offer it. So I think the court is just simply saying, if she was offered a PBT and took it or didn't take it, that may change my mind, but that's not an issue here because it was never offered, so I'm not going to consider that. I think that's merely what the court is doing.
The district court?
District court. And so I believe it was a misunderstanding on the Court of Appeals of saying that the district court gave it much more weight than I believe it actually did.
What are you asking for us to do exactly? And how give us a roadmap on how to get there?
I'm asking the court to ultimately overturn the Court of Appeals decision, of course, and I'm asking this court to find that the Court of Appeals was wrong in assessing their standard of review and reweighing the facts. I merely want this court to find that there is substantial competent evidence for the district court to make the finding that it made, and ultimately agree with the district court and reinstate Ms. Casper's license.
Do you have any more questions? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning and this afternoon. Court will take this matter under advisement.